So good morning, everybody. Thank you very much for inviting me. I've been asked to present the EU readmission policy in general with a specific focus on the EU-Turkey readmission agreement, obviously, and to explain a little bit the distinction between this agreement and the deal of the 18th of March between the EU and Turkey. So the first part related to the EU policy on readmission, look a little bit at the standards, let's say, in terms of readmission and the key implementation issues that we have been faced with in this policy. So the first thing is that, and I guess that you are all aware of that, but it's I think it's always useful to remind that return is an absolutely key requirement of the EU migration policy, because without an efficient return policy, it is simply impossible to prevent illegal migration flows. What we see everywhere is that regardless of the dangers of the routes, especially the route, the so-called Central Mediterranean route, for instance, which is much more dangerous than the Western Balkans one, sub-Saharians are ready to face those dangers because they know that once they are in the EU, once they have reached the soil of the member states, the likelihood that they will be returned is very limited because of the failure of our return system. So we need to improve our return policy. We need to go beyond those 40% of return decisions which are effectively enforced overall in the EU and which constitute a very strong incentive to irregular migration. And there is now a very strong political willingness to change in this situation. That was probably not the case some years ago, but with the migratory crisis that we have been facing since last spring, you have seen in the various council decision, European Council decision, this strong willingness to change that situation. Well, of course, the first thing, of course, is that readmission, or let me just take a step back. We have two issues with our return system. One is internal, that our procedures are basically too burdensome to effectively return people. So that's our problem, I would say. But the second part of the problem is, of course, the lack of cooperation of the returnees, which is quite understandable from their perspective, obviously, and the lack of cooperation from their countries of origin to recognize their nationals. Because the situation we are faced with is the following. Irregular migrants hide or delete their passports and their ID documents, and then try to conceal their identity and their nationality to prevent their return. So we need, when we are faced with those people, the cooperation of their country of origin. Of course, our member state police authorities are quite used to this situation, and they will be able to identify what is the likely nationality of a person, but that's one thing. You need, of course, to confirm that with the authorities of the country of origin. And there, we can, of course, and we reaffirm that quite often, that readmission is an obligation under customary international law, and that obligation is not contested. I mean, I've never been faced in my discussion with third countries to a country which would deny that it has this obligation to readmit its nationals who are staying irregularly in another country. But of course, they then say, well, of course, we are ready to readmit our nationals, providing it can be proven that they are our nationals. And that, on this point, they do not cooperate. And if we do not get this cooperation, it's indeed quite difficult. So the rationale for a readmission agreement is quite simple. It is simply to establish some administrative procedures with the country of origin to facilitate the identification of the persons and the issuance of travel documents. That's the core of a readmission agreement. So in essence, those readmission agreements are very technical in nature. They have nothing to do in principle with human rights, for instance, because all those, compliance with human rights take place before. We readmit a person once we are satisfied that that person is irregularly staying, has no right to international protection, so everything takes place before. So once the person gets a written decision, and at this moment, the process of readmitting that person can begin. Since the Treaty of Lisbon, this is an EU competence, which nevertheless is not exclusive in the sense that the Commission, to negotiate a readmission agreement, will need a mandate from the Council, negotiating directives approved by the Council. And when there is no such negotiating directive, member states can still negotiate bilaterally a readmission agreement or a kind of softer form of agreement, such as a memorandum of understanding. So since the beginning of this policy, of this EU policy, the EU has received, the Commission has received 22 negotiating directives from the Council. You have the list of the countries on the screen with the years when the negotiating directives were adopted. So this year, in 2016, the last negotiating directive to be adopted was for Jordan in the framework of the mobility partnership with this country. And we have also proposed a mandate for a negotiating directive with Nigeria, which is likely to be adopted in September. And then we have 17 agreements which are in force with third countries. And you have here the countries with which those agreements have been negotiated and concluded, and the date of their entry into force. So the last one were in 2014, which was a kind of good year with 4 agreements, including, of course, Turkey, the most important one. In terms of content, overall, the structure of the readmission agreements are fairly standard. You will find the same type of provisions in all readmission agreements. So, of course, with the years, the structures have slightly evolved. We have added, for instance, provisions regarding to fundamental principles, which are obviously not necessary in a readmission agreement, but which were considered as being a kind of positive sign, notably vis-à-vis the European Parliament, for instance, and also with the third countries with which we were negotiating. And of course, each agreement, each negotiation has its own dynamic, so you would find some differences, some small differences in terms of deadlines for replying to the readmission application and so on. But again, if you look at them, the structure is very similar. So you first find the definitions, very classical, as well as some reference to fundamental principles, non-affection clause, and so on. And then you arrive at the core of the system, which is the readmission obligations of the other party, and then the readmission obligations of the EU. Because all readmission agreements that we have are reciprocal. Of course, in practice, it is mainly in one sense, that we ask third countries to readmit their nationals, but legally, the readmission agreements are constructed as a full reciprocal agreement. So the first one is, of course, the readmission of the nationals, which includes normally the spouse and the children of the national, even if they do not get the nationality of the country with which the agreement has been negotiated. And of course, the famous third country national clause, which is sometimes more difficult to be accepted by some third countries, and which basically imply the readmission of the persons who have transited through the territory of the third country before entering into the EU, or who have a right of residence in that third country, even if they are not a national. So exactly the same thing for the EU, obviously, pure parallelism. And then you have again the core, the second part of the agreement, which are the procedures. So the principle, we have the accelerated procedure for the border cases. So if someone is caught in the border region, there is a kind of accelerated procedure. There is basically, depending on the agreement, like 2-3 days to respond to the readmission applications and return the person. You have the content of the readmission application, how it should be done, what kind of information should be there. So all kind of things very technical, just to ensure that the readmission process can take place. Very important element, of course, the means of evidence to determine if the person has indeed the nationality of the country of origin. So we distinguish between proof of nationality and what we call prima facie evidence. So in the case of proof of nationality, the third country is not supposed to have any further examination and should accept that proof of nationality and readmit the person. When there is prima facie evidence of nationality, so I mean evidence which are less less importance, then they should be accepted, except if the third country can demonstrate that in fact the person is not of their nationality. Then you have some very key elements are time limits. How much time has the third country to reply to the readmission applications? Once they have replied to the readmission application, how much time they have to issue the trial documents, and then in how much time should the readmission take place? The two first ones are very important because first of all, in those member states who have a kind of efficient detention system where the person can be placed in retention for a sufficiently long time, it means that if the third country takes time to reply and to deliver the trial document, the returnee may stay a long time in detention, which is not something anybody wants, of course. The other issue is that in those member states who have a too short detention period, this is the case, for instance, in France, in Italy, in Spain, then we have the problem that if the reply does not come sufficiently quickly, then the administration has to release the person after the expiration of the maximum duration of detention period. And then the return is a failure. So that imposes on us a burden when we are negotiating with the third country, because we have to ensure that the timelines for the replies fit with the constraints of those member states who have the shortest detention period. There are a number of elements related to the transfer, in which condition the transfer can take place. The readmission in error, an error can always occur, obviously, And in that case, member states, of course, will take back that person. The other elements of the readmission agreement are the transit operations. So transit is a little bit different. It's when you return someone in another country, transiting through the territory of the party to the agreement. So in the case of Turkey, for instance, it is quite relevant because Turkish Airlines has a very extensive network, which which deserves a number of countries where you have no direct flights from member states, and it is therefore quite useful to be able to use the flights of Turkish Airlines to return some people in those countries. You have provisions related to the costs, obviously, data protection, relation to other international obligations, and then you have the Joint Readmission Committee and the implementing protocols. So the Joint Readmission Committee is basically the committee established by the agreement and whose task is to ensure and look at the correct implementation of the agreement. So when the implementation is smooth, the meeting of the Joint Readmission Committee are not of paramount importance, and with some countries we have not had a meeting of the Joint Readmission Committee for a number of years. But when we are faced with some issues in terms of implementation, or at the beginning of the implementation of an agreement, then we may need to have several meetings of the Joint Readmission Committee in 1 year to ensure that all problems are solved or can be solved. Implementing protocols is basically ensuring that for a number of even more technical details, member states can sign with the country concerned an implementing protocol. So that can be the establishment of contact points, ports or airports where the person can be returned. Again, very, very practical things which are, does not make sense really to put that in the readmission agreement. Then we have the provision related to the relation to the bilateral agreements of member states. I mean, when we negotiate with a third country, it is quite often the case that that country has already previous agreements or memorandum of understanding with some member states, and the basic principle is that the EU readmission agreement takes precedence over the bilateral agreements between that third country and the member states. So far, of course, as the provisions of the bilateral agreements would be in contradiction with the EU readmission agreement. So if they deal with things which are related more or less with what you can find in the implementing protocols, like contact points and this kind of thing, this is of course not a problem. Then you found the classical provision related to the title application, the entry into force, and then all the annexes, the applications, the forms for the readmission application and transit application and so on. So to look at the effectiveness of this policy, the first thing is perhaps to look at where we are in terms of return rate. Basically the return rate is the ratio between the effective returns and the return decisions issued to a specific country. So as you can see, I mean, as a reference, we have the total, meaning for the whole world. There were a little bit more than 500,000 return decisions issued in 2015 in the EU, and less than, around 220,000 effective returns, which comes to a return rate of 42% exactly. And then you see the figures and the rate for the countries. So as you can see, with the countries with which we have a readmission agreement, so as you can see, apart from few exceptions, all return rates are above the EU average. So you have Fyrom, which has a very good return rate of more than 100%. You find someone that, I mean, it may be surprising, but it can happen, of course, if some return take place in a year while the return decision was taken the year before, obviously. So that can explain the differences. So you see that we have still a number of countries with which we have a readmission agreement, but with which the return rate is below the EU average, while in general it is much above the EU average. So this is the case of Pakistan. This is specifically the case for 2015. In 2014, the rate was better, but in 2015, we have had a number of issues with Pakistan, and there was almost a de facto suspension of the agreement towards the end of the year, which explain that quite unsatisfactory rate. Turkey is below average, and I'll come to that. We have then Armenia, which is also below average, as well as Cape Verde. Well, in the case of Armenia, strangely enough, I was in Armenia this week for the meeting of the Joint Readmission Committee, and member states are quite happy, in fact, with the way the agreement is implemented globally. So the issue is more, in fact, on our side than because of Armenia. I mean, a number of Armenians are quite good at trying to prevent their return, even once they have been issued a return decision, by absconding, by, using all sorts of legal ways to prevent their return. On the implementation issue, the major problem is the lack of political commitment. Readmission agreements are legally binding, but very clearly there is, if a country does not respect a readmission agreement, what do we do? It is not legally enforceable. There is not, we cannot go to a court or something like that. So it is a matter of political willingness. So of course, when a country signs a readmission agreement with the EU, it is a signal that it has the political willingness to respect the agreement it will sign. But that political willingness can change in the time. And in this case, we need to see, if we see that a readmission agreement is not respected anymore, what type of pressure are we ready to exert on that country so that it respects its commitments. So that's the major issue, and I will be short on the Turkey agreement in practice. Well, I will go directly to the readmission agreement itself. So, first thing, of course, the readmission agreement was entered into force with Turkey, entered into force in 2014. The third confidential provision was supposed to enter into force 3 years after the entry into force of the agreement, so 1st of October 2017. But as a result of the deal which was made in fact, in November last year, this process has been accelerated, and the entry into force has taken place on the 1st of June 2016. In terms of implementation, we have two issues, for Turkish nationals and for third country nationals. For Turkish nationals, the agreement has entered into force now for 1 year and a half. And Turkey does not respect the agreement, does not implement the agreement, let's be clear. The problem we are faced with is that consulates, Turkish consulates, are in charge of recognizing their nationals. And they are faced with certain pressure from their diaspora. And we see that in several countries. That pressure can take different forms. It can be, like gentle pressure. but it can be also physical threats. It can be to the council, or it can be also corruption. So we are arguing for a system which would be more centralized, where the decision would be taken in Ankara rather than in the various consulates. But in fact, it's quite clear that the Turkish government, does not want to irritate the Turkish diaspora, who has a significant weight in the elections, because they can vote, of course, in the national elections. So we have this first problem. When it comes to third country nationals, well, it's a little bit early to tell, since the agreement has entered into, this provision of the agreement has entered into force since 10 days. On top of that, Turkey is claiming that, yes, the provision has entered into force, but for that its actual implementation, they still need a decision of the Council of Ministers. But of course, we have some return which take place from Greece to Turkey in the framework of the deal of the 18th of March. Well, perhaps this on the deal itself. So you know that there is a number of political commitments which were taken in this EU-Turkey statement of 18th of March. I will, of course, not go through all of them, focusing on return. So in terms of return, what has been agreed, as you know, is that all irregular migrants arriving in Greece after 20th of March will be returned to Turkey, either because they are, even if they are legitimate asylum seekers, but because in that case, on the basis of an individual assessment of their claim and on the principle of safe third country or first country of asylum, their claim will be deemed inadmissible in Greece, and they will be returned in Turkey, where their claim will be assessed, or where they will be protected in the case of Syrians without having to make that claim. There were, of course, that was a very important element of the deal, and in exchange, there were several things. Of course, the resettlement scheme, so for each Syrian, not each irregular migrant, but each Syrian returned to Turkey, one Syrian will be resettled, into the EU. And then, of course, the visa liberalization, which is a very important element for Turkey, as you are aware. Well, perhaps I will stop there. There are a number of challenges, of course, in the implementation of this statement. Some of them have been solved. A lot of work has been done in the hotspots, in both Greece and Turkey, to adapt the legal system in terms of mobilizing operational resources from member states, from the agencies, and in order to coordinate all this. But I will just finish on this. What is the effectiveness of the deal of the 18th of March, of the statement? So the numbers you see on the graphs are the average arrivals per day. So at the peak of the crisis in October last year, there were almost 7,000 arrivals per day in the Greek islands. Now we are at 47 arrivals per day in average. So of course, there was a reduction before the deal because it was winter time, and then as a result of the closure of the border by Macedonia, but you can see the effectiveness of the agreement when it comes to irregular migration. And then you have the figures of returns from Greece to Turkey in the framework of this statement. So we are not talking about the EU readmission agreement, but in the framework of this statement, there has been so far 462 returns. Much less, of course, than the irregular arrivals, which amount to a little bit more than between 8,000 and 9,000 since the entry into since the statement has been implemented. Because I mean, there is this individual assessment. People may claim that Turkey is not a safe third country as far as they are concerned, for instance, and that takes time to process, but I think you have been, this has been already explained. And resettlements, so of Syrians to the EU member states directly, from Turkey to the EU member states, 511. So a little bit more than the returns, but of course you cannot have a pure one for one at every moment. Thank you very much.
Thank you very much, Chair, and good morning, everybody. I am Minos Mouzurakis of the European Council on Refugees and Exiles, ECRA. We are a pan-European alliance of over 90 non-governmental organizations working with refugees and asylum seekers in Europe. And I'm very grateful to my previous speaker for introducing the topic of the EU-Turkey statement and its implementation, as this will relate quite closely to our findings from Greece. What was a very interesting feature, and it was just mentioned about the challenges relating to the implementation of this political agreement on the ground, is the operational framework. Just to explain, we have a peculiar situation of an EU political agreement with very important and potentially far-reaching regional consequences in practice. Various different actors from the national and European level involved in the application of these terms, but in a national context. This means that in legal terms, the agreement, as far as the return component is concerned, needs to be implemented by Greece towards Turkey. Now, the interagency model and the involvement of different actors in this process has led to two very important issues. One relates more to the legal changes that have come about, as mentioned, on the Greek side in order to prepare the implementation of the agreement. And the second one is more practical questions, to which I will get in a bit, relating also to what we saw during our visit. What would also be good to do would be to give the floor afterwards to my colleague Danai Papachristopoulou, who is a Greek lawyer and who was also in Greece during that visit, to complement also with some of her observations on the ground. Now, on the legal challenges mentioned, there's been a lot of attention from media and other sources on the necessary legal changes that needed to be done in Greece to make sure that the agreement can be implemented. And as you probably know, there was a very substantial reform of the asylum system done at the beginning of April, so a few weeks after the statement itself. Now, this is very often presented as the kind of legislative byproduct of the EU-Turkey deal, which is partly true, but on the other hand, it was a much larger reform. So this actually introduced a very substantial institutional reshuffling of the Greek authorities dealing with migration and asylum. It transposed the recast asylum procedures directive, so it brought about quite a few changes in the asylum process as a whole, and at the same time introduced a few specific measures that could be of interest to this discussion. One thing that might be useful to clarify from the outset is that the notions of safe third country and first country of asylum, which, as we've heard yesterday, are key to this context, were not new creatures, let's say, in the Greek asylum system. One of them, the first country of asylum notion, was slightly adapted, but these pre-existed the EU-Turkey deal. And neither before nor after the EU-Turkey deal has there been a legislative recognition of Turkey as a safe third country by Greece. This is something to be done as an individualized assessment in every single case. One important change that was brought about by the April law was the introduction of a specific regime in the border procedure that existed already in Greece. So that, again, is an adaptation of something that was already there. This basically enabled the Greek authorities to determine, in cases of emergency and of exceptional pressure, special measures that could be taken, which involve a fast track or accelerated or whatever we may call it procedure at the borders, which happens now on the Aegean Islands, which basically involves the entire process being completed within 14 days. So it's already a very truncated procedure for applying for asylum, getting a first determination, and applying and submitting an appeal for a second instance decision. What is also very important in this context is the role of EU agencies in this regard. So this particular procedure allows, in those exceptional circumstances, the Greek asylum authorities, the entities that are in charge and are responsible for those decisions, to be assisted by officials of EASO. Frontex also has similar roles now codified in legislation for their support relating to first arrivals. So this interagency model, which could be seen as a blueprint for something broader than the Greek context in the future, has now been introduced to some extent in the law. Another very important respect in which a national legislative framework is amended in this regard has to do with even more recent changes. So without getting into too much detail on the safe third country notions and how these have been interpreted, we heard yesterday that the appeals committees, the second instance bodies in the Greek asylum framework, have taken a number of decisions, most of them rebutting the safe third country presumption in respect of Turkey. This was mainly done by examining the specific criteria of the safe third country definition. One part relates to whether Turkey respects the principle of non-refoulement in practice. Another one, which is probably key to this inquiry, is to what extent the protection that refugees may obtain in Turkey is actually protection in accordance with the Refugee Convention. Suffice it to say that most decisions of the Appeals Committee to date have been positive for the asylum seekers concerned. Against this backdrop, there has been a further reform of the Greek asylum system as far as appeals are concerned. This happened very recently, so only yesterday afternoon the Greek parliament voted on a very quickly introduced legislative amendment to the law. This came in the context of the Greek law on economic development, which includes a provision amending the asylum law to that effect. This brings about two noteworthy changes. Firstly, as far as the composition of these appeals committee is concerned, there has been a substantial modification. Previously, as you may have probably heard, these committees, which are an administrative body, were composed by a government official, a UNHCR representative, and a representative appointed on the basis of a list of the National Commission on Human Rights. Under the new design of the appeal committees, they will remain an administrative body, but composed by two judicial officials in Greece and a UNHCR representative in principle. This has already raised a few issues around constitutionality and compliance with basic principles, insofar as judges would be involved in a body that would not be judicial in nature, and it's a question that might be worth raising and has been raised by the Parliament when debating this provision. The second one, which is also very important in light of the presentation we had yesterday on the right to an effective remedy, is a curtailment of the right to be heard in appeal proceedings. So whereas the April law allowed the applicant to request a personal hearing at the appeal committees as long as they submitted that request 2 days before the appeal, this has now been deleted following yesterday's amendment. So that means that in less cases would it be possible for the asylum seeker concerned to have their cases heard by the appeal committees rather than an examination sur dossier. As far as some of the practical issues go, what was quite interesting during our visit that we conducted together with the AIR Center, Advice on Individual Rights in Europe, to Lesbos but also to the mainland, where some of the effects of the design of this particular approach, which sees an interaction between local actors and European or international actors, pretty much at all different fields of involvement. So we have not only Greek authorities interacting with EU agencies or other authorities from different member states. We have similar situations as far as NGOs are concerned, even as far as independent volunteers are concerned. This has led to very often roles not being sufficiently clear in terms of who assumes responsibility for different actions and who should be the main interlocutor for refugees and migrants entering the Greek territory. Just to illustrate an example, as said before, the legal framework foresees now that in those particular circumstances, EASO officials can support the Greek Asylum Service in the registration and the initial processing of asylum cases, the final decision being incumbent upon the Greek authorities to take, since this is a national law procedure. Very often we've seen situations where decisions are often served by authorities other than the Greek authorities, decisions drafted in English rather than Greek, that very often relate to the involvement of EASO officials in the preparation of these cases and in the conduct of admissibility interviews with applicants. Now, beyond raising obvious procedural errors that could be challenged from a legal perspective, this could also be quite illustrative of some of the practical difficulties in terms of properly coordinating which authorities have which responsibilities and to what extent. What is also very important to bear in mind is that a role that is, again, not particularly clear between the interlocutors themselves becomes even less clear to the individuals concerned. And this is probably the most important finding that we came across, both on the islands and in the mainland. People are very poorly informed about the procedure they need to follow. There is a lot of confusion on who the main authorities are, what the role of EASO is, what the role of UNHCR is often, or of the different Greek authorities involved in that process, or even the different NGOs that are present in those spaces, but also on the procedure that they actually need to follow. And bearing in mind that as soon as an asylum application is lodged, the process is one that goes very, very fast, and very often without the necessary legal assistance and representation to make sure that the person can navigate this process appropriately, it's of course very easy to create frustration and to create very practical difficulties in this regard. Just a very final point about legal assistance, and then I might hand it over to Danai. This is one of the key elements that is needed in Greece, not only relating to the return component and being able to challenge returns on, again, an individualized examination of whether an asylum application should be inadmissible on the basis of Turkey's safety, but also for other reasons why an applicant should not be returned or should be channeled to a different procedure in the mainland. And there again, we have seen that the scarcity of capacity in the existing Greek structures to be able to provide such legal assistance is a major challenge that should be addressed through the appropriate channels. Again, because we have a situation where the necessary legal framework is the Greek one, and the only persons that can do legal representations are the qualified Greek lawyers, this is a very important component of coordination that should be taken into account in this regard. So I might hand it over to Danai for any observations from Lesbos, if that will be okay. But I look forward to any questions. Thanks.
Thank you. I will not take up a lot of your time. I completely agree with the description of what's happening in Moria. The most disturbing fact is the legal vacuum that we found there. I was there for only a few days, and I was there as in an observer capacity on behalf of the European Bar Association, the CCBE. At first instance, we weren't allowed to go into the camp of Moria, which was a challenge to enter, but thanks to the great support of the Lesbos Bar, we were able to go there and speak with a person who calls herself the camp commander. While we were there, the scenes of detention of minors for 25, 30, for 35 days, in their best interest, as the camp commander said. Pregnant women sleeping on concrete floors. The camp is basically doesn't meet any of the safeguards, also according to the Greek inspectors. That's the closed camp. The open camp is a lot better. There are 2 open or 3 open camps there. But again, what we've seen, and also which ties in with the presentations earlier, with the border closing on Macedonia, you didn't have any more transit movement. You have a lot of people, and the only who are basically stuck on the island and stuck on the mainland, and the only option they have is to ask for asylum. Half of them don't know what asylum is, but going back to Turkey, you know, it's a Hobsbawm's choice. In fact, they have to go and ask for asylum. And with that consolidation of the stream of people asking for asylum, the need for legal assistance becomes even more apparent. It's strange to see on these islands that there are doctors there, lifeguards there, cooks, but where are the lawyers? My legal profession has been absent where it should have been present from the start. So when I reported this back to the European Bar Association, an initiative grew. It's the European Bar Association and the German, the DAF, Association of Lawyers, to bring down European lawyers to Lesbos. And our aim, and we will start in June, is to assist the Hellenic bars and give individual advice to asylum seekers, not to represent them in Greek courts, because obviously that's not something that we can do. We are there to facilitate and not to litigate or to poach cases. It's a very sensitive issue for Greek lawyers. However, giving the sheer numbers of asylum seekers and people who are clearly in need of international protection. So, you know, often we speak about asylum seekers, but you can't, if you look at the streams of forced migration, it's very difficult to stop. Where does human trafficking start and asylum stop, and so forth? So if we're talking about people who are in need of international protection, they need good, solid information in order for them to make their decisions, whether they want to try and continue in the procedure, or some of them want to go back to Turkey. I mean, let's not forget that there are lots of Syrians who do not want to come to Europe. You know, in the political framing, we see a lot of people saying, oh, you know, it will be flooded by Syrians. There are a lot of Syrians who rather stay in Turkey than come to the EU, and I think that's an important issue as well. So we are there to provide information, to also make sure that there is some monitoring on the rule of law, because at the moment it's a complete mess. I'm sorry to be blunt and to be Dutch in that way, but you know, it is a mess. There are people being served documents. The police don't know what documents they're serving, what they're actually meaning, because today they might mean A, but tomorrow they might mean B. And I'm not saying that people are doing this out of malice, but the lack of coordination and the lack of support down there means that you know, we have got an important role to play there as lawyers. So what we're hoping to do is to open a camp, open in the camp at least a facility where people can come for individual advice. And the idea being that if they're being interviewed by EASO officers and the asylum interview is in English, we can go through the interview with them and add information, provide additional evidentiary proof in order for the quality of these asylum procedures to be enhanced. How will it work? It will work on a roster system whereby lawyers from EU countries are asked to go down to Lesbos in first initiative and afterwards on the mainland for a 2-week or 3-week period. It will be entirely pro bono. So what we've done is we've got the European bars have donated money for this project, and we now have somewhere near 180,000 euros ready, and this money will be spent on flights, accommodation, and per diem money to eat, and for cars and rental cars and rental space in order for it to work. So all the lawyers going down there are doing that entirely for free. And it's a temporary measure that this project, because ideally the Greek lawyers should be able to handle the situation themselves. But you know, if there are, again, if it's clear that this is a European problem rather than a strict Greek problem, then the logical conclusion must surely be that we need to put our shoulders behind it as well as European lawyers. The selection of the lawyers will be done by the national bars, because the CCBE and the DAF in Brussels cannot determine whether lawyer A, B or C in whatever country fulfills the requirements. And there's been a call out by our president of the CCBE for lawyers to go down there and to join up. And once that will be done through the national bars. And once this selection has taken place, the administrative staff in Lesbos will be making rosters so that people can sign in to certain slots. I think it is very important that we're down there. And one of the big challenges is not just asylum, but it's a much broader scope. For example, medical problems. For example, fitness for detention. And somebody, there are lots of doctors there, and you have CPT standards on detention, but these doctors don't know what the standards are. And if you could just get a doctor, or if you can explain to a doctor that some people are not fit to be in detention, then you could probably persuade the Greek authorities that they should be sent to an open camp. I'm just giving you an illustration of the need for good information in a bigger range than just asylum. Another problem down there is what has been called altruistic hobby lawyers from far, far afield, thinking that we want to help these people, and the Greek law is complex of itself. Asylum law is very, very complex. So if you're doing banking law in California and you are on holiday and you think, oh, I'm going to give some free legal advice, not a good idea. So in other words, I think it's crucial that European lawyers, European asylum lawyers, pick up the role that they should be playing, and this has been recognized. And any of you out there who practice asylum law, you're more than welcome to join us from June onwards, and actually start helping these individual people who need, are desperate need for information and for support.